Thank you for having me today. My name is Suzann Moskowitz, and I run and own the Moskowitz Firm, which is a small boutique firm I'll tell you about. The work that I do, which is largely in trademark and copyright, is not state specific. So that means I really get to work with people all over the world to help them protect their content and their brands. And we'll talk about what that really means. Well, I just love working with artists because I love art and I want to support art, but unfortunately, I am personally talentless. So this is like a workaround for me in a way that I can help promote art and learn about local art talent. But there are so many reasons to consult with a lawyer, and as I'll explain later, it doesn't have to, doesn't have to break the bank. One thing is, if you're an artist, you run a business, your business might be under your own name, it might be under another business name. So actually that's a trademark issue, protecting that name, or even just at least clearing that name to make sure you're not stepping on someone else's toes. The important thing that we think about when we have a painting or a sculpture or something is actually registering the copyright in that. You have rights to any work you create as soon as it is put down on paper or built. But actually protecting it, which means going to the U.S. Copyright Office, is a really important part of what I do. And it is so much better if we do these filings before there's a problem, for a lot of reasons, including the ability to actually get statutory damages, which will make it a lot easier to fight if you have to. Another proactive reason to come is to talk about things like fair use. Okay, so fair use is the idea that in your own work, you're incorporating someone else's, whether it's their brand or a piece of their art. The word appropriation. Fair use is a very sticky concept. And a lawyer is only going to be able to give you some guidelines. Ultimately, it depends on who's on the other side. We deal with a lot of bullies in our industry, a lot of luxury brands that don't like to be messed with, a lot of people that don't have a very good sense of humor, even if you're doing something humorous in your work. So getting a lawyer's take on something before you make it public may help you with kind of reducing the risk. And then of course, if you're doing, let's say you're the kind of artist that's doing the same kind of thing with some regularity, maybe you're a graphic designer or something like that, I can help with standard contracts so that you don't have to reinvent the wheel every time you have a new client. Now, so those are all the sort of the proactive steps. What often happens, like I said, is that people come to me the first time to deal with something reactive. And reactive doesn't necessarily mean bad. It might be that they're presented with an opportunity to do work for a municipality, the opportunity to do some kind of commissioned work for somebody. And that's really exciting, but it may be a level of formality that the artist isn't used to experiencing. So a lot of times we're scrambling because they present us with a contract. They say we have a few days to respond. And sometimes the inclination is just to sign it. It's an opportunity. But what I try to do is kind of provide a reasonable level of due diligence to make sure that an artist is not entering into an agreement that might harm them in the future or really restrict their rights or put them in a situation where they're bearing some risk that they may not have thought of. So that's the kind of the opportunities. There's also responses. It's possible that an artist will get a letter that isn't exactly a cease and desist, not exactly a threat that they have to stop, but somebody has a concern about something that they've done. This happens in the space of appropriation sometimes. So responding to a letter, not assuming that a letter is going to have to turn into a full-blown dispute. I'm not a litigator. I don't want to go to court. I want to keep people out of court. So I like to give people reasoned advice to try to soothe things and settle matters as best as we can. I really can't emphasize enough how important it is to be proactive. When I've had situations where an artist has found that their work has been copied and we didn't have an application at the Copyright Office in advance, the best that they could hope for is getting the person to stop, not getting any real financial remedies because it's so hard to prove actual harm. And then it's just a scramble. It's an expensive headache, heartache to see your work being exploited. And even if your work, whether it's, something that, you're seeing being reproduced on websites across the country, or you just see one person who's obviously taken advantage of something that's clearly stemming from your protectable work, it really is a lot of heartbreak. And so one of the things I do, I walk people through that heartbreak, but I really try to take those opportunities where we're being reactive and think, okay, what can we do in the future? to make sure this doesn't happen again, to make sure that your rights are protected, and next time we don't have as much of a mess. And really, when I say it's not a lot, a copyright filed at the Copyright Office can be as low as $45. If an attorney helps, that might add something to it, but there are a few ways to get it, attorneys involved through pro bono arts organizations like Volunteer Lawyers for the Arts. That's an organization I'm a part of. I also take on pro bono engagements, a certain number a year, and I base it on the need and the circumstances and the benefit of the project to the community. I also, and other lawyers that I work with, am often willing to provide a reduced rate and a flat fee when there's a situation where it's not necessarily a nonprofit, but it's somebody who could just use a hand. One of the things I've really tried to do is be a resource in the community.